All right, today we're going to trace the path of a lawsuit from start to finish. It's this whole world with its own set of rules, big strategic plays, and yeah, some pretty high stakes. We're going to break it all down, step by step.
I mean, we've all heard that line a million times, right? In movies, on TV shows. But what's actually going on behind the scenes? What's the real journey from that angry threat to a judge's final decision? Well, that's exactly the map we're about to follow.
So here's our game plan. First, we'll figure out where this whole thing even begins, which court to choose. Then we'll see how the first legal shots get fired. After that, it's time to play detective and hunt for evidence before we finally get to the big showdown and find out what happens when the story doesn't end with the verdict.
Every lawsuit, and I mean every single one, starts at this massive fork in the road. Before you can do anything else, you have to make a huge decision. Which legal universe does this fight even belong in?
You see, in the US, we have this dual court system. Think of state courts as the main highway. They handle almost everything, from your speeding ticket to giant corporate lawsuits. Federal courts, they're more like a special, restricted express lane. They are courts of limited jurisdiction, which is a fancy way of saying you need a special pass to get in. And it's the law, not you, that decides which road you're on.
So how do you get that pass for the Federal Express Lane? And really, how do you get your foot in the door of any courthouse? Well, you have to get past two really powerful gatekeepers. The legal key to unlock those gates, it's a little thing called jurisdiction.
Gatekeeper number one is subject matter jurisdiction. This is all about the court's power over the topic of the lawsuit. It's basically asking, hey, is this court even allowed to hear this kind of story? A family court isn't going to hear a case about a patent, right? That's subject matter jurisdiction in a nutshell.
Now for federal court, there are two main entry passes. The first one is called federal question, and it's pretty simple. Your lawsuit is about a federal law, say a civil rights issue. The second one is diversity jurisdiction. This one's interesting. It exists because way back when, there was a fear that a state court might favor its own local folks over some out-of-towner. So to get in this way, you need two things. First, complete diversity, meaning no one on the plaintiff's side is from the same state as anyone on the defendant's side.
And the second piece is the amount in controversy. Basically, what you're fighting over has to be worth more than $75,000. It's a pretty high bar, and it's set that high on purpose to keep smaller, more local fights in the state courts where they belong. So just remember, total diversity between the parties and more than 75 grand on the line.
Okay, let's say you're past that first gatekeeper. Now you face the second one, personal jurisdiction. This one isn't about the case. It's all about the person you're suing, the defendant. It's really a question of fairness. Is it fair to make someone from, say, Florida, fly all the way to a court in Oregon to defend themselves? To figure that out, the courts have a test. To see if it's fair to sue someone in a particular state, courts use this three-part test. First, they ask, did the defendant purposefully avail themselves of that state? Basically, did they intentionally do business there or reach into the state in some way? Second, does the lawsuit have a direct connection to those specific actions? And finally, third, does dragging them into court there align with traditional notions of fair play and substantial justice? It's a fundamental constitutional check to make sure the system is fair.
So once you've cleared both jurisdiction hurdles and you're finally in the right court, the lawsuit can officially kick off. This opening stage is called the pleadings, and it's where both sides get to write the first chapter of their legal story for the court to read.
It's really a three-step exchange. The plaintiff, that's the person doing the suing, files a document called a complaint. Then, you have to officially let the defendant know they're being sued through something called service of process. And finally, the defendant has to respond either with an answer to what the complaint says or with a motion that asks the judge to do something, like maybe throw the whole case out.
But here's the thing, you can't just write whatever you want in that complaint. The Supreme Court has really raised the bar. Your story now has to be plausible, not just something that's vaguely possible. And that's a huge deal. It means you can't just go on a legal fishing expedition. You have to lay out enough facts to make your story believable from the get-go.
So the first chapter's been written. Now we enter what is often the longest and, the most expensive part of this whole journey, discovery. This is the great fact hunt. It's where both sides are basically forced to lay all their cards on the table.
And lawyers have a whole bunch of tools for this hunt. They can send written questions called interrogatories that have to be answered. They can demand to see documents, emails, you name it. And they can do depositions. That's where they get to question witnesses under oath before a trial ever happens. Every single one of these tools is designed to dig up facts and see just how strong the other side's story really is.
But hey, it's not a complete free-for-all. There are limits. You can only go after information that's actually relevant to the case, that isn't protected by some kind of privilege, like your private conversations with your lawyer, and importantly, is proportional to the case. You can't ask for 1 million documents if you're only fighting over $10,000. It has to make sense.
Okay, after that great fact hunt is over, we've finally reached the climax. It's showdown time. But here's something that might surprise you. Most lawsuits, they never actually see the inside of a courtroom for a full trial.
And this is a big reason why. One side can ask for summary judgment. They're basically saying to the judge, look, even if we pretend all the facts are true for the other side, the law says I win, so let's not waste our time with a trial. Or, even in the middle of a trial, a judge can stop everything and grant a judgment as a matter of law, a JMOL, if it's obvious one side's evidence is just way too weak to possibly win.
But if the case does push forward, the 7th Amendment to the Constitution kicks in, and it guarantees the right to a jury trial in most federal civil cases. And that's really a cornerstone of American justice, having a jury of your peers be the ones who decide what the facts are.
Now, even when the jury gives a verdict, the story might not be done. The person who lost can appeal, which means they ask a higher court to check the trial for any major legal mistakes. But, and this is a big but, there's a critical rule called the final judgment rule. It means you can't just appeal every little thing that happens along the way. You usually get one shot at an appeal, and it's only after the whole case is completely over in the trial court.
So, after this whirlwind tour, what do you think? All these rules are here for a reason, right? To make things fair, predictable, to make sure everyone gets their day in court. But those exact same rules can create a journey that's incredibly complex, super expensive, and takes forever. So is it a clear map to justice? Or is it a maze that's just too easy to get lost in? You know, maybe the real answer is, it's a little bit of both.